to the flag of the United States, to the republic for which it stands,
First up, can I get a motion to approve the agenda as presented tonight?
I motion to approve the agenda.
Okay, a motion is on the floor. Can I get a second?
Second.
A second. All in favor?
Aye.
Aye. The agenda is approved. Next, we're going to go into our new business then. Okay. So going into new business, we are here today because there is a hearing for a petition for Ms. Gail Lambert, who has submitted an appeal to permit 4242, which is specific to Mammoth South. Would you like to explain any more of that, Carla?
As the appeal reads, the following reasons for the revocation of the building permit are presently known. 1, there is no decommissioning plan for the properties that are the subject of the building permit, while a plan is in place for a prior phase involving different parcels in a different permit. No plan is in place or was submitted specific to the properties relating to the building permit. Number 2, there was no road use management agreement approved by the commissioners. In fact, Jenny Monroe with VS Engineering stated in the commissioners meeting on March 17th, 2025, after the issuance of the building permit, that the county and VS Engineering are still in negotiations with Mammoth Solar regarding the terms of the RUMA. Number 3, upon belief, adequate financial assurance has not been provided to the county. That certainly was not provided in a RUMA approved by the commissioners, because such a document did not exist when the building permit was issued and does not exist now. So with this information, documents in the building department were submitted that have been considered exhibits that have been given to the board and to Gail Lambert's attorney. Reading number 1, there is no decommissioning plan. There is a decommissioning plan that was dated and submitted Friday, January 17th. And we have a plan for Central 1, a separate plan for Central 2, and a separate plan for Mammoth South. Number 2, reading, there is no road use agreement. There is a road use agreement that was approved by commissioners dated November 3rd, 2022. Number 3, no financial assurance has been provided to the county. And we have bonds dated November 3rd, 2022, another one November 3rd, 2022, February 4th, 2025, and January 30th, 2025. All of those permits were submitted to the building department on those dates.
Okay, going on from there, there are a few things that I want to discuss before we really get into this. Is 1, this is a public hearing specifically for us to go over this appeal. This appeal is outlined by the 3 things that are mentioned in here. So this is not a referendum on solar. In fact, my opinion on solar or anyone on this board's opinion on solar directly do not matter to this. This is a simple, did these documents exist or did they not exist? So I just want to make that very clear because that's why we're here today. So the evidence should be able to prove one way or another if it exists or didn't exist, and we should be able to move on. Going into this next section then, I'm going to give Mrs. Lambert or Mr. Kuchime, you have 15 minutes as defined by our procedures. Have the floor.
Thank you. So, my name is Jason Kuchime. I'm an attorney with the law firm of Snyder Morgan Kuchime, 4211 Clubview Drive in Fort Wayne, Indiana. And I represent Gail Lambert and the Jaybird Farm Trust, dated January 2nd, 2020. Gail is a trustee. Trust own real estate and they reside in the county. What brings you tonight, as you indicated, is my client's administrative appeal, building inspector's decision to not revoke permit number 42, which was issued to Mammoth Solar, not issue a stop work order in connection with a permit. Did email a number of documents to Carla at the end of last week. Tribute to each of the board members here. I've also handed out a copy in the binders there. Tabs and whatnot. A little easier for you to follow along as I'm talking here tonight. Before I jump into the merits of the arguments, I do need to request that Abby Schilder-Dickey excuse herself from tonight, from participating. In the first pocket in your binders, you'll see a copy of Indiana Code 36-7-4-909, which confirms that a BZA member has a conflict of interest, may not participate in a hearing, they are biased, or if they have a direct or indirect financial interest in the outcome of the hearing. Also in that front pocket of your binder, you'll see a list of parcels that was included in the Mammoth Solar grazing project, which includes parcels owned by Kurt Dickey, Abby's husband.
It's Scheidler Dickey, by the way.
Apologize.
Mm-hmm.
Intentional.
Mm-hmm.
But we do submit that participation in that Mammoth project creates a conflict of interest. Ask that you participate. Planning to use? Well, if you are biased or if you have a direct or indirect financial interest, have a conflict of interest, use, not participate. Her husband has signed leases for the project.
Not the project
Or the
or
Mammoth
the grazing.
Which, get into that. That's tied into this.
So I'm just going to ask Ms. Dickey, Tyler Dickey, do you have, for the permit that we are seeking tonight, do you have a conflict of interest based on that directly?
Say that one more time.
For the permit that we are looking at this evening, do you have a direct conflict, direct or indirect conflict with or prejudice?
I mean, deciding whether or not we have paperwork, I don't feel like I do. But if our attorney feels like it's easier just not to have that, I'm happy not. I mean, I just, you three were gonna vote, right? I mean, I don't care how you vote, I'm just saying. Because we need a quorum, yes? Right, I'll just recuse, that way there's no. But with that, I don't feel like I do, just for the. Great, Secretary.
So it sounds like we have a recusal.
Okay. So then moving on then to the merits of tonight's appeal, you'll see at tab 1 in your binder, there's a copy of the notice of appeal that was initially submitted to the inspector detailing some of the failures that Mammoth Solar failure to comply with the UDO's requirements in order to secure the permit. Some of you have been on the BZA for a while now. I know, Bob, you have been as well. And you were part of the special exception proceeding with Mammoth Solar that was initially approved by the BZA, but then was subsequently reversed by the courts on appeal. And you'll recall that the UDO at that time had some detailed requirements for an application for special exception for commercial solar, and that Mammoth failed to comply with many of those preliminary requirements. As such, the court held that this BZA's approval of that incomplete application was arbitrary and capricious, and they reversed the BZA's decision. It just serves as a reminder that the UDA's requirements are in fact requirements. They're not suggestions. They're things that have to be complied with. And while the UDO now allows commercial solar as a permitted use as opposed to a special exception, the UDO still contains a number of requirements that must be met in order to qualify for a permit. And if those qualifications, if those requirements are not met, cannot issue a permit. There's no discretion, and we believe that's the case here. Now, the permit at issue was approved by the building inspector on February 25, 2025. One of my clients spoke to the building inspector in March of 2025, and she stated that the permit involved 685 acres of real estate. Tab 2 in your binders contains a report from Nathan Orger to the council dated February 10, just 2 weeks before the issuance of the permit. And that document includes some language stating Doral has 600 some acres that it wishes to move from the Mammoth project to the proposed Mammoth grazing project. In light of this, the company wishes to add 684.56 acres to the Mammoth project, which are listed and mapped in the resolution packet. This requires a new permitting process, and Doral has begun working with our building inspector on this. Frankly, it makes sense. You're adding ground to a prior approval. That project changes, the impact, changes, has different impacts on different people, requires a new application. Same as when you pull in property out of a project. Requires the new application. This new permitting process for that 685 acres is what led to the issuance of permit 42. When you look at materials before you, the council did deny Mammoth's request for tax abatement. That's 605 acres. Tab 4 contains relevant portions of your UDO. It discusses the requirements for solar energy systems permit applications, and Chapter 7 also contains some additional requirements. 7.4 requires the submission of a signed and executed decommissioning plan before construction can commence. It specifically states that if not, the building permit will be revoked. Not may be revoked, but will be revoked. Construction has commenced for permit 4242. I will discuss the propriety of the decommissioning plan shortly. Tab 4B includes a copy of section 7.18 of the UDO. And that confirms that before a building permit can be issued, a decommissioning plan must be submitted to the building inspector, who is to certify that it complies with all applicable regulations. And the same is true for the drainage agreement. It has to be signed by the drainage board before a permit can be issued, and it must be developed in conjunction with the county surveyor and the drainage board, among others. And the same is also true for the road use agreement. That has to be signed and approved by the commissioners, and it has to identify the roads that are to be used in the project, among several other things. So in order to kind of learn more about this application process and the permit and what was submitted, I tendered a FOIA request, Freedom of Information Act, to the building inspector. Copy of my request at tab 5. So you'll see in there I asked for a lot of things. All the documents submitted in connection with the permitted issue, including the road use agreement, the drainage agreement, the decommissioning agreement, all the other documents. Tab 6A in your binder, that's a copy of the road use agreement that I was provided in response to the FOIA. And you'll note that that was dated November 3rd, 2022. And that was for Mammoth Central and Mammoth South. That was not for the property or the project that is the subject of permit 4242. And that is the only road use agreement that was provided. And again, I just noted, permit 4242 could not be issued without a road use agreement for that specific project. And not only that, if you look towards the end of the RUMA, the road use agreement, page 21, they're numbered on the bottom of the pages there. The appendices to that agreement were not completed. They were not included. The document was not complete. There was no roadmap that existed at the time. There was no roadmap that was approved at the time. There was no map of the installation. There was no map of the driveways and entrances. If you look at page 22, 23, you'll see they are all blank. That was an incomplete document. And those documents did not exist in November 2022 for the land and project that exists under permit 4242 or for any other project. So you've got the 1122 road use agreement was incomplete. It did not apply to this project. The next 3 tabs are minutes from commissioner meetings. Those all were after the permit was issued. And they all confirm that the road use agreement is still being negotiated. And I've highlighted several languages, several portions of that. So the permit's issued in February. You've got minutes there in March and April and so forth where they're admitting that the road use agreement is still being negotiated. And again, go back to 2022 when it was allegedly approved, it was incomplete. So, in some of those minutes, in particular, you look at April 21, the solar consultant for the county said that the central map has been approved. I'm told that that approval didn't specifically come from the commissioners. There was no, you go through all the minutes and talk to the folks that were there. It was never during a public hearing was there a vote or a discussion on these maps at any time. The last tab on Exhibit 6, that is a map from the county's website, and that was not provided in response to the FOIA request, probably because it didn't exist at the time, but it was pulled directly from the county's website. And that appears to be, some of those maps that were later approved, discussed in the minutes there. But again, those are not the properties at issue in 4242. So you've got no road use agreement associated with 4242, and certainly that did not exist before the permit was issued. Tab 7, that's the drainage agreement that was provided in response to my FOIA request. Just like with the RUMA, this document is also dated November 3rd, 2022, years before this permit was issued. And it is for different projects, it is for different parcels, like with the road use agreement. And the appendices, you go to the end of that document, similar to the road use agreement, they're blank. They didn't exist. There's no maps. While the maps were later submitted at some point, again, those maps related to Mammoth South and Mammoth Central, and not the property or project that is subject to permit 4242. Tab 8 includes decommissioning plans that I was provided in response to the FOIA request. The first 3 tabs include plans for Mammoth South, Mammoth Central, the projects. Those are not signed by the commissioners when you go through those. The only one signed by the commissioners is the last tab of Exhibit 8. And that agreement, again, just like the others, was incomplete. The attachments were either incomplete or they weren't even included altogether. And again, that document for a different project and for different parcels than are at issue with permit number 42. Other defects that are at issue here, but again, time is short tonight. But what is clear is that we do not have a road use agreement, a drainage agreement, a decommissioning plan approved by the commissioners in connection with permit number 4242. And the unrelated documents that were signed by the commissioners, those were incomplete when permit 4242 was issued, so they can't rely on those otherwise irrelevant documents. So under the clear language of your UDO, permit 4242 never should have been issued. And without those documents in place, a stop issue or a stop order must be issued in connection with that permit. So as such, we would ask that you enter an order reversing the building inspector's decision and issuing a stop work order for all work in connection with permit 4242. Just like the first approval of the special exception, the failure to do so we submit would be contrary to law, would be arbitrary, capricious. Thank you.
Going on from that, Carl, would you like to speak on behalf of that?
The road use agreement is for Mammoth Central and Mammoth South with Pulaski County Commissioners as it reads. Maps were submitted to my office. I have maps from Mammoth that did include the south section dated November 5th, 2024. I have a Pazer study showing the maps dated April 2023. I have another Pazer study January 28th. I have additional road maps. I have several additional road maps. I have a February 3rd. I have November 21st of 2024. I did have, I believe the gate maps were emailed to you, Mr. Kuchme, on April 10th. Also on Friday, April 25th at 2:53, when I sent you decommissioning as well as the road use agreement, It looks like I had sent that to you 3 times. I said, let me know if there's anything else you need. Additional note for the public access request, were you planning to come in or send someone for review copies, scans of the documents I'm not able to send to you due to their size? And I had not gotten a response.
The maps identified here that we've looked at, and I just want to make sure those are encompassing then of the project that's in question. I mean, I know that there's more than that involved in this, but I want to make sure that specifically the ones to permit 4242 are also listed.
They do show that south section, yes. I'm looking
And
at
that's
one
that
dated
right there.
December 24th, correct.
Okay.
And it's even on the drainage map dated November 21st, 2024. Yes, no, that, because that 685 was part of that, is part of that ground, that's that, at 600 and 800 around that proximity. And then also on the west side of the highway.
Add so that stick to go with the maps.
No, that is the 685. That's for that. There isn't any other parcel that we don't know about that was submitted with the application. Correct. Or maybe not that exact number, but maybe 684 point something, but
Sounds like they knew this was coming, so they had it in the maps. That's
apparently.
my understanding based off of the dates on the maps. But I can see the parcels.
Yes.
So that, I'm not gonna say that covers, but that's discussing one of the 3 things that were mentioned. Do you have any comments on the other 2 items or any additional one?
I do have a signed decommissioning agreement, and that it reads that Mammoth is to sign that, and I do have a signed copy.
What exhibit was that? Was that? 'Cause you submitted 3 exhibits back, correct? Exhibit A, B, and C. So for the road use agreement, that would have been Exhibit B, right?
Correct.
So for the board, we have this to take a look at and make sure that we're looking at the right thing and making sure that it is dated and making sure that it's encompassed to this building permit.
Had that thing document from Nathan, said that they were wishing to add 685 acres across 11 parcels to the Mammoth project. This requires a new permitting process. So the 685 is what you're telling me now, those were being added Mammoth South? Is that the position? They were not in Mammoth South at the time the decommissioning plan was approved, at the time the road use was apparently approved, at the time the drainage agreement was approved.
I have nothing to do with the drainage agreement. This
Right.
is about road use.
But I just want to be clear that,
The road use agreement is between Mammoth South LLC and Pulaski County Commissioners.
Sure.
Yes.
Okay.
There is no language in the road use agreement that is specific to any parcels.
right, because those documents didn't exist at the time.
The language in the road use agreement does not speak specifically on parcels. There are attachments that are maps, and I have maps.
So I have a question. Is there someone from Mammoth that can speak to this question? So my question specifically is, I'm just going to try to cut out the middleman and ask directly. My interpretation of what I have seen is that you submitted your original plans, or that Mammoth submitted their original plans and kind of foresaw that this was going, so they kind of had it mapped out on maps, but when they applied for previous building permits, that was not the piece being permitted, but it still existed on the map for the future plan. Is that not accurate, or can you attest to where these maps came from?
Certainly. And a little bit. Chris Shellman of Gouin. So
big picture, to answer your question, the road use agreement, the drainage agreement, and the decommissioning, particularly the road use agreement, talking about the road use maps, it doesn't cover any specific parcels or anything. All it has is an agreement between the county and Mammoth, to which there are no third-party beneficiaries to even be allowed to complain about it, right? So is an agreement between us and the county, which sets forth how we will maintain, how we will pay, and how we will. Specifically, we had the initial project that did not include the 685 acres change. All we need to do for the road use agreement is to designate roads prior to use. When we do that, we send them to the building commissioner. Communicate, we talk, we hash out what we think makes sense, and then we move forward. No response, it's deemed approved by the building commissioner. We did a first iteration in October of 2020. That was with an initial construction phase that was smaller. Then, as we proceeded to go to full construction, for the whole project, it made sense to take 685 acres that we had for another project, go forward with it, and not go forward at that time with 680 some acres that were the equivalent. What we did then is submit new maps for the road, and it's not just submitting maps, right? There's a lot of requirements to the road use agreement, none of which BZA should be expected to. That's way outside of the. But we provide the maps, go study the roads, buy the study, got all the documents. There's over 3,000 pages, road studies, drain studies. Plus, I can't fit them in the box, but there's 12 hours of video that Gary and the county has. So all we need to do is submit new maps and new information before we use them. We did that. So specifically, we submitted the final project designs. These project designs that were submitted and approved included the 685, but for clarity, we also include the entire project for Mammoth Central 1, Mammoth Central 2, and Mammoth South. And one aside on that, that's clearly permitted under the ordinance, which states that you can have aggregate project applications. So all we were trying to do is make it simple and easy to understand. We don't need more stuff floating around. We have an agreement that covers the roads that was in place. And in place since November 3rd, 2020, what is it? 3rd, 2022. And we can continue to update the maps throughout the life of the project. And we've worked with the county to do that. They've had concerns and we've changed them. And we continue to do that. We will continue to have conversations. Tim's present. He can tell you about those. We set maps, we change them. We've probably changed them 8 or 9 times, but that's how the agreement is intended to be used. It's meant to be iterative. It's supposed to address concerns that evolve over time as the project evolves. You know, the road use agreement talks about multiple phases and multiple projects. Commissioning plan talks about everything can be phased in and done in multiple projects, aggregate projects. But specifically, the maps were provided in August, November, December, January. All of those were different iterations based on discussions with the counties. All of those include the roads related to some acres.
So I guess this is more of a question for Carla, but I may ask you a question as well. So based off of what I've got here, on you have January 17th, 2025 as the most recent submission of these documents for the road use agreement, correct?
Yes.
And that is inclusive of everything that they would need for this project. Understanding that addendums happen, but like for the requirements necessary to issue a permit were all at that time you have them.
Correct. The ordinance reads that they need a signed road use agreement, signed by Mammoth and signed by the commissioners. And I received that in my office. Mammoth South. It read Mammoth Central and Mammoth South.
Now, Mr. Kuchme pointed out that there was a whole long list of things that the ordinance says has to be in that road use agreement. I don't remember which tab it was under, but it was one of the. Do you recall? Okay. Are we certain I think it's this right here. Are we certain that that was listed, that it met the requirements of that?
The road use agreement was signed, and it's with Mammoth South and Pulaski County Commissioners, and it included road maps. There's something specific that you were...
General location key with arrow, approximate location of any substances. Like I just,
We have a site,
That's the
we have site plans.
Okay.
That's
Yeah.
the site plan. That's also included in that.
okay, so I was looking at two different pieces.
To be clear, the premise is the road use agreement existed. To the extent that they alleged there was any non-compliance with the road use, it really doesn't have anything to do with whether the permit should have been issued. That should be handled under the road.
Because
use
it was signed
agreement
by the
directly. Correct. There's one in place that existed, has existed. Have the right to provide more maps that cover different roads and things. There's no reference to the lands.
Any questions from the BZA specific about that? And we'll just go through these one at a time and then we'll go to other things. Okay, so I think we've talked about the road use agreement then, at least I have a grasp of it. Let's talk about the decommissioning plan. Carla, would you like to go through when and how that was delivered?
So as mentioned earlier, we have a decommissioning plan for Central 1, decommissioning plan Central 2, and decommissioning plan South. These are all dated as your copies in your packets show January of 2025. When you go into these decommissioning plans, you will see that Mammoth did include maps on those. There is also a decommissioning agreement that was signed.
I'm going to ask for clarification. So we keep seeing decommissioning plan for Central 1, Central 2, and South. I keep going back to the permit number, 4242, is that the only piece of the South section? So when we say Mammoth South, are we only referring to the project listed in 4242, or is that a bigger picture?
That is added to the Mammoth South project that was already...
So this is in addition to this
Correct.
piece. Okay.
Yes, yes.
We submitted full plans with.
Okay. And that's what's listed then.
South, see the circled area.
Right.
That's the new.
Figure 2.1 Mammoth South Solar Site. It's on page 4 in the Mammoth South decommissioning plan.
Allows for planting and acreage to be added as the project progresses.
Anything else to add about the decommissioning plan? So you're just affirming that it does exist and it is complete then? Or
Correct.
any questions from the BZA representatives over here in regards to that? We don't have a question for you yet. If might ask one, but do we have any other questions from that section? Seeing no other sections from that, then let's go ahead and take a look at the bonds. Exhibit C, so the final assurance bonds. So looking at the final assurance bond, so this is, once again, I see several of them. The most recent would be for January, or looks like the most recent is actually February 4th of 25. And then there's also some in January 2025. This says that it was submitted on the 4th and the 30th.
Yeah.
Okay.
Or that was a clerical error.
So for the purpose of that, if you look at the Exhibit C section, it says 1 and 2 November 3rd, 2022. That should actually be 2025.
No.
Nope. Okay, sorry. The February 4th date should be a February 24th, 2025. So with this, can you state, Carla, what the requirements were specifically for the bonds? The bonds, I think, become confusing because it requires different amounts of money, different stages. Can you clarify that for us?
Well, not 100% with bonds, but let me see the... So as I'm reading Pulaski County Ordinance Section 7.3 liability, well, 7.4 decommissioning plan.
Bonds that question.
We'll ask you in a second, okay? Let us do our thing first.
So in regards to some of the bonds, I went ahead and included in your packet every bond that we have received. And every bond is from Mammoth South. This language in the 7.4 for decommissioning is for financial assurance that coordinates with the cost estimate for decommissioning. So that is the February 4th bond that you have. And the concern based on this is in regards to no adequate financial assurance provided in a road use management agreement. You can see in the packet for Exhibit C, well, you have 100,000, you have 300,000, there's 800,000, here's a 5.3 million. I'm sorry, I'm trying to get performance bond for right-of-way permits. It's got the number 4 at the top of your page of Exhibit C. So you have a couple road use performance bonds in here from that forward. And then instructions, indemnification, and then there is another 100,000 and another 800,000 bond and a $5 million bond is on your last page.
All right. Do you guys have any questions about that? I have a few I'm going to ask. I'm actually going to ask Mr. Kuchme if you don't mind. So I guess I'm confused on this one because I can see the bonds, I can see the numbers. What is missing about the bond piece to this?
Ties into the same argument, like, for example, on the plan, just going back, only signed copy, signed by the commissioners, was in October 2020. The 685 acres had not been added yet to the project. That change required a new approval. There was no subsequent new approval of road use agreement, commissioning plan, or of any of the bonds. This all, they started, the addition of that property to the project started the process over, required a new approval. They didn't do that. It's kind of just the same argument with all of this.
Because, I mean, when I interpret that, to me, this was going to be, I think, my biggest concern, because obviously with a larger project, you're going to need a larger bond. So I guess my question is this is, are there bonds, do these bonds cover the project? I mean, I can see that they have been added, so I know it's not just the original bond set. I can see that some were added as recently as February, which is also the month the permit was issued. So my question is there enough bond to cover the requirements? Absolutely, Mr. Shulman, if you, I'm okay with
the different amounts.
Provided in March to Central. So I would say another 10 or more than 10 bonds were also added.
do these, so that's in my mind after though, because this was issued in February.
After.
So what I
all
want,
related and all for the benefit of the county that can be pulled on for any reason.
and I appreciate that. I guess what I'm trying to wrap my head around right now is, were there adequate bonds issued at the time that this building permit was issued?
Yes.
For this specific permit?
Yes. There was a Mammoth South decommissioning bond that was originally $800,000 and increased to $5 million.
Okay.
In January 30th.
And at some point in some exhibit, and this is more of a question for Carla.
Those were added to the plan agreement.
Okay.
Specifically, they were provided because it also had been 2 years since the original study had been performed. We performed an additional engineering study by Lockmuir that came up with the calculation. That study was provided provided to Carla to add as an amendment, an addendum, not an amendment, an addendum to the decommissioning plan. And then bonding was provided based on that.
All right, so I think that answered my question for you from now then. I guess at some point, like, so this is, Carla, help me remember this. I know we've been given like 240 pages worth of documents in the last 3 days to read and understand. It was last minute submitted. So I want to ask you, in something that we were submitted or read, there was a piece of information showing how much bond was required versus how much we received. I don't remember where that was, and there was an excess. Can you tell us that?
There is an excess, and that is in the decommissioning bond. And when you look at the cost of decommissioning, and you can take any of your decommissioning plans, and it shows on the table, and those are the last couple pages. So it will show you total cost of demolition, and then they show scrap value. So then obviously subtracting scrap value from decommissioning cost, then that leaves you with a decommissioning amount. The bonds did exceed those for decommissioning on what they had given, and so I gave you those, but this argument is over the road use bonds.
Correct.
Which is also, again, what I gave you.
So that was a different argument. So in looking,
Bond is also bonded. As you can remember, we were talking about maps. The original maps that were provided showed way more miles. After we did that, we bonded 24 million map provided back in August and November. Those, Terry has some concerns that came up that we addressed and reduced the number of miles. So we have not changed that bond. That bond is over.
I stopped you earlier from talking. You're welcome to come up and say whatever you had to say. Okay. All right. I just want to make sure that you had a chance to be heard. Does the BZA have any other questions about this so far? Okay. So at this point, do you have any questions or that you want to get reiterated?
No.
I will open this specifically up then to the public. If you have anything you'd like to present that is relevant information to add to the record, reminder that this isn't about solar. So relevant would be something that is specific to this application, that specifically is about the existence of a road use agreement, a decommissioning plan, and assurance bonds before the permit was issued. So if you have something to say that is relevant, please sign in and we can go from there. Does anyone have anything? Go ahead, sir. Do we have, I got a question. Did you fill out a form? Okay. And so just to reiterate, you have 3 minutes, okay?
Okay.
You got that. Go
So
ahead.
in Stark County, the question would be, have they been taking care of these bonds? Because I know that the payments, these solar panels are just sitting there idle. They're not generating any power at all. They're built to look like they're generating power, but they're not connected to the transmission line. That's giveaway number one. Way number two, there are no battery plants for these solar panels.
I'm going to ask that you stick to the relevant topics. We're talking about bonds,
So the topic is so will they? So the question is their honesty on the bonds. Will bonds? Are they going to, like, they keep expanding it? Are they going to be good to their word as far as like paying those bonds off? Also, the landscaping agreement. In Stark County. I mean, you can see
this is Stark County.
with your own eyes. Yeah, well, Stark County is actually 5 miles away. We should actually go there, and we have the benefit that they took the plunge.
I understand that. I'm going to interrupt you for a second. Please pause this time. I want to make sure that we're clear, though. This is not a hearing on solar. This is not whether we like it, whether we don't like it, whether they're keeping their promises, their agreements. That's not what this is about. My opinions of this don't matter. Your opinions of this don't matter for this hearing. This hearing is specific to, did these documents, do these 3 things, did they exist at the time that the building permit was issued? That's all we're talking about today. So that's what I'm asking you, if you're going to speak, which I hope you do, Stay relevant to that topic, please.
Well, okay, as far as the road use agreement, I know that 700 south of 14 is almost like a highway. I drove by there. 5 or 6 trucks on the road at a time going by. So, question is, Carla, did they actually, has anybody done an impact study of their road use? Things that will impact the county. Is the agreement correct? And yeah, I could go on about landscaping again. I know that Mammoth drew up like a plan of 3 different scenarios. They had a company in Virginia put a plan together, 3 different scenarios for landscape.
I'm going to say relevance one more time, and then if we can't stay on topic, I'm going to ask you to sit down.
Okay, well, yeah, that's all I got.
All right, thank you.
Things you can see with your own eyes, like no connections. Stark County, there's some dubious things going.
Okay, so that's all he's got, so let's go on. Does anybody else have anything relevant? And like I said, I'm really not trying to be mean about this, but I need to be specific about what this is about. This is about what has been put into the petition. So if you have something to say that's relevant to this petition, and once again, I'll go over those 3 things. If it is to the financial assurance bonds existing, the decommissioning plan existing, or the road use agreement existing, please come and state what you have. But we have to stay relevant to those pieces because that's all we can legally make our decision on. Like I said, I want to make that very clear so we don't have continuous issues.
Hi, Suzanne Morrow in Pulaski County. I am concerned. Yes, I did. Yes. I am concerned when I hear somebody come up and say they're switching it from this and they're going to do that, and then it's for grazing, and then they decided it's something else. And also, if you've got all these different bonds and they're increasing the amount of land for the solar, how are you going to keep up with all of this? I mean, it just sounds like higgledy-piggledy that you could actually let things fall through the cracks because of all these changes. And I would just like to really make sure that the bonds are what they say they are, that they're legitimate, and if they should go belly up or bankruptcy, that those bonds are actually really true and in place to take care of the decommission, of taking out all these panels. So that's what I'd like to say.
All right. You're good. You have 3 minutes, sir.
Has anybody checked out the financial on issuers? Very common for bond issuers to go bankrupt.
All I know is they're certified bonds. So they're certified bonds. And it doesn't, in our piece of information, that's not our role. Our role is to say, do the bonds exist? That's the county deals with the majority of. But any other relevant statements related specifically to this?
Hi, my name is Brianna Schrader. I'm an attorney at Jansen Schrader Ag Law in Indianapolis, Stone Avenue Crossing. I should be signed in there. I represent a group of landowners involved in this project, landowners involved in the solar project. And I want to make sure that as we're talking about Mammoth and as we're talking about the opposition, we don't lose track of the fact that there are real landowners who own the property that we're talking about. They have rights. They're here to support the project and to oppose the appeal, which I have quotes here. I have got 3 points to make. Some of this, I'm sure you'll appreciate, I have to say because I have to put it on the record now, or I, speak now or forever hold your peace. So, first of all,
can I pause you for 1 second?
Yes.
I just want to, well, please pause your time. I just want to make sure that we have it on record. You said you're signed in. Are you speaking on behalf of yourself, or are you speaking on 3 landowners that gave you 10 minutes, or are you? What are your?
I will speak on behalf of landowners. I can give you last names. I think I'm still going to take, it's going to be 4 minutes, 3 minutes.
You have. So
I think I was the very first one to fill one out.
We have others that have filled in to give you their time. Okay.
Mr. and Mr.
Okay.
offered if I need it, I'm going to be quick, so
Okay,
I'm hopeful.
I just want to make sure that we're all
Okay.
covered here, so then
Yep.
you do have,
I
Right.
appreciate it.
you may continue.
Okay, first of all, and again, some of these are things I need to say on the record now, or I don't get to make the argument later, so I think it's important to say it now. First of all, we do have the landowners involved here. They have got due process rights, the right to rely on the county process being upheld. So in other words, as the president has stated, it isn't about whether someone likes or dislikes solar, rather the landowner should be able to rely on ordinance, the agreements, the documents that are in the file. As you've heard and seen from Carla, from Mr. Spellman, the question documents exist. They're in boxes in front of you with Carla's exhibits. And the landowners have a property interest, right, in being able to rely on. And I don't want that to get lost in the process. I don't want this to become an arbitrary process. If someone dislikes solar, we can, well, forget about those documents. Sucks. Let's move on. That's not how the process, not how the rules. Second of all, heard my counsel, Cooch may mention that the building permit in February never should have been issued. And I wrote that down as a quote, because that's what they're really trying to appeal here 5 months later, the building permit from February. But it's simply too late, right? They could have appealed that back in time. That ship has sailed. Again, the failure to kind of timely object, to timely appeal, means that right is gone. Again, the landowners have the right to rely on a building permit that has been issued 5 months ago. The other, kind of the flip side of that, if we set that aside, what you also heard is they're essentially appealing a non-decision, right? There's not a decision that can be pointed to. The decision that I think they're trying to appeal is building administrator, zoning administrator, not doing what they wanted. There's not a decision that's being appealed. And you really can't appeal the lack of a decision. That's not how the process works, right? And the attempt to, I guess, force the zoning administrator to do something by saying, we're challenging your decision, you've got 10 days to agree with us, or else. Let us remind you of the litigation history in this county and what the Court of Appeals did. None of that is relevant here. You can't appeal a non-decision. Simply not how the process works. Play that out to its logical extreme, right? That could mean every month we could come back here. Every month there could be a new appeal. Well, we don't think this piece of it was done right back in January, and so now we're here for another appeal. And then we can do this every month. Job security for lawyers, not much else, right? So, I mean, really, if you look at it that way, the question of, is this even the proper procedure, proper remedy? Do the petitioners have standing? Are they truly aggrieved? Is not this question moot already? These are all legal arguments, but to serve in case there's an appeal down the road. So those questions about remedy really dovetail back in with the actual landowners who are impacted here, the property owners who have those due process rights to rely on a standard procedure, zoning ordinance in accordance with the statute, rather than some arbitrary. We would echo the arguments by Mammoth that the substantive agreements in question are present in front of you, and so they exist, and that's the only question that was really properly raised. To the extent you can argue that it was properly raised, there's no decision being questioned here, other than maybe a building permit 5 months ago. So, on behalf of the landlord, I'm happy to answer more questions. Time for Mr. Spellman.
Give you time for that. Can we stop her time, please? And where is she at currently? 5 minutes? Okay. I'm going to put that on hold because I have some questions for you because I'm seeing some things that I want to make sure I touch base on. That's fine.
Okay.
Yeah, you stay up here. So I guess, question about what you're stating is, I don't necessarily think that I agree with some of it. I think you'd mentioned that we can't appeal something from 5 months ago. And I just want to touch base and say that we can if it's done in a timely fashion. And in this case, if you look at the documents and you look at the appeal process, that was completed correctly. So it was given, I'm not quoting the dates because I'm looking at it, but they had so many days after they met that requirement. They met those requirements in the appeal process of this. So I know that we're having this hearing 5 months after, and that's, I think, circumstantial, but the pieces to getting there were met. And I would say that that's not their burden. I think the reasons why we're here now today and not here 3 months ago is not their piece. That's more of our board's, the way it was scheduled. I guess my question is, were you meaning something different than that, or is that?
No, again, I think it comes back to, I have one shot, right, to say what we need to say, and we're talking about a building permit from February of 25. I hear what you're saying, but I just need to preserve my rights to make that argument down the road, should this go down the road.
Okay. I just want to touch base and make sure I wasn't missing something that I thought I wasn't missing. So, okay.
Absolutely disagree with me. I've got to be very careful to cover our bases.
Okay. All right. Thank you. Mr. Shulman, did you want to take the remainder of your time?
Really is quite simple. Brandon said, first, a couple quick things. One, petitioners have no justiciable issue here tonight. Quite frankly, made up. At best, it's moot because it's been resolved. And
let's not interrupt, please. Let's let him get through his statements.
And the remedy being sought is not available. The BZA does not have the authority to issue a stop work order. The BZA does not have the authority to revoke the permit. Going forward, the parties are not aggrieved because no one's aggrieved. There's nothing wrong. They can't even cite anything that's wrong. All they have are fears, made up fears. The only things that they said we didn't comply with are requirements that don't exist. Mr. Kuchme created them out of thin air. There's no restriction on what land the road use agreement covers. There's nothing. They're coming in here with their eyes shut and saying, why not turn on the lights? They're on. Open your eyes. It's all right in front of you. Thousands of pages of documents that have been provided to Carla. And it's not her fault. They have to make an issue out of everything. We've been here before. We've provided all these documents. I want to make sure that all the documents provided are in the record. I want to make sure that all the documents that were provided to Carla are in the record. I know this isn't everything. It's just a small sample of the thousands of documents provided. So when they act like nothing, they don't know what's happening, that's just not true. All of the acres are specifically there. There was one massive site plan that was provided for everything for clarity. And now they're trying to manufacture this false confusion. It's just, quite frankly, it's not honest. It's all right there. Now they want to go before the BZA and they want to try to argue about a contract. The BZA doesn't argue about a contract. They want to argue it here because they can't file a lawsuit to fight about it because they have no rights to do it. The contract specifically is between Mammoth and the county. That's it. It says right in it. So they're trying this end run to make chaos. And I'm sorry you're here to have to deal with this. I'm sorry. It's a waste of time. I get it. But Carla's not some judge. There's a document. It's signed. It covers the topics. It's as simple as that. Have a decommissioning plan. You have multiple exhibits prepared by engineers that cite how much. You have multiple bonds that cover those matters. The ordinance specifically allows for multiple projects to be done under single application. There's a road use agreement that's been in existence and been utilized. We think there's a road use agreement. We're operating under it. Tim sends us stuff every single week on it. The county talks to us about it. It's as simple as that. There's a drainage agreement. We talk with the county twice a week in meetings about both of these agreements. We think there's an agreement. They think there's an agreement. He signed it right over there. Who is someone else to say there's no agreement? It's nonsense. So I guess in that, I'm happy to provide and show you every single parcel of land, but it's really simple. Thank you.
Do we have any other individuals that would like to speak? Ms. Knievel first, and then Ms. Knievel, do we have paperwork for you? Okay. Are you on staff yourself, or do you have others? Okay. One paper, 3 minutes.
On paper, it's myself. Can you hear me?
Yep.
I do want to mention, I know you guys don't have to speak back and forth, but, I've spent commissioner meetings talking about the bonding and the assurances. What I just heard tonight that there was a bond for 85.3 million. Did I hear that correctly? Did I hear a bond for 85.3 million?
I didn't say that, no.
Okay, I thought I heard that, and then I heard something about another 10
Maybe I had
million.
said and 5 million.
Okay,
But
okay,
I can show you, there's the bonds we've had emailed back and forth, but I
right.
can
So
show
the bonds
packet.
that we have emailed back and forth are the bonds currently.
Yes,
So the total decommissioning for Mammoth Solar is at between 63, 65 million, but the bond assurances we currently have are about 15 million total for the decommissioning. Am I correct there?
no, we have, I don't know where those went.
I mean, as of the commissioner meeting, when I was asking questions directly about the bonds that we had in place for decommissioning were a total of they were 5 million per location, Mammoth South, Mammoth Central 1, Mammoth Central 2. And I know those can grow, and I know Mammoth, South is just about done. So are we still at just $5 million for Mammoth South, or has additional bond been set?
They did increase a couple bonds. Here's one for 25 million.
When was that?
This one, the January 30th and
Is that
is
for
February
road? Is
4th
that
was
road
the
use
new
though?
one?
Is that road use, Carla?
The January 30th is
That was road use. So I'm
And the
speaking,
4th. Yes.
about decommissioning.
Oh, I have so many here, Jenny. I'm sorry.
And you can look into it, but from the last time I questioned that at a commissioner meeting, the bonds for Mammoth South, Mammoth Central 2, or whatever, the three were just over 5 million each. But the total in decommissioning was between 63 and 65 million for the project. So I just want to make sure I've got that right. And you can look into it and you can get back with me later. I do also want to say that, we heard from Ms. Schroeder, I think that was her name, that the process and the rule of law should work for every property owner, but currently ordinances are being disregarded. The ordinance for 75 feet back from ditches have been disregarded. The 150-foot setbacks that Carla, you yourself have said were made clear from the outset are being disregarded. So the ordinances work and the rule of law should be followed for every property owner in Pulaski County, not just the ones who have ground in solar. I want to make that clear. We have also been waiting on a site plan. I just heard the site plan referenced. I know, Carla, you've been waiting on the site plan from BF&S. Do we have that yet?
No, I don't. I had sent an email this afternoon, though, as
Okay,
a
so
follow-up
we really don't know without that site plan. I know we've gone back and
with
forth
the
about.
markup. Right.
I'm going to
with the
ask,
markup.
is the site plan relevant to one of these three documents? Okay.
Well, I believe it is, but maybe it's not.
I don't think it is. That's why
Okay.
I want you to get
And then I did just hear from Mr. Shellman, he stated the contracts are between Mammoth and the county. Then why wasn't the $225,000 to develop these agreements paid to the county and rather paid to Mr. Kevin Tankersley? But you are correct, Mr. Shellman. The contracts are between the county and Mammoth Solar. But you yourself, Mammoth Solar, paid $225,000 directly to a county attorney and not the county.
I'm not going to touch
Thank
the
you.
relevance. I don't know anything about that, so I'm going to. Once again, she spoke her time. Let's not address it out loud, please.
Money was not received by Pulaski County.
Okay, go in. Do we have? You want to go last, or do you want to go ahead and go next? It's up to you. Does anybody else have anything to say before Ms. Earl goes up? I'm doing this in your favor, I think. So.
My name is. I live in Winter. I am a very passionate Pulaski County. I'm going to speak non-legal. I'm not going to pretend I understand everything that is going on, but I'm going to speak what I have diligence up to speed over what has taken place in our county in the past.
Before we give you your full time, I just want to make sure.
Yes,
I'm going to reiterate.
It's to that.
That's all I wanted to say.
Yes.
Thank you.
From what I'm seeing, and again, I'm not going to state that I've had the privilege have in front of you and I have the level of understanding to do it because I've not been able to do that due diligence. I hope and pray you have, and I'm with the, but a lot of the turmoil over the past few years, from what I see, my personal opinion, based on what I'm hearing tonight on road use, decommissioning, and the financial insurance bondages, is it boils down to interpretation. So I would like to ask you to please be cognizant of your role to protect Pulaski County, because while there are landowner rights for the solar farms that are here that are protected, and as they should be, there are also non-solar farm land rights that want to be protected, and we as community members are at risk if we don't have proper protections in place now and 30 years from now. So what we decide today, what we do today, has a long-term impact, and I just want you to consider that. We are current. We should not be left to interpretation. The BZA not being expected to interpret, and I'm not trying to be controversial, but I think you should. I think if you are going to be speaking on things, voting on things, and approving things, I hope you're doing your due diligence. Again, I'm going to presume that we have, but a lot of what I see from the documents is different interpretations. I'm just going to ask for your consideration of what's true and right and protects us against risk.
I'm just going to say, I'm listening to you, and I will address specifically to you once we're finished with everything, because I do want to speak to you about, out loud, of course, but I do have something to add. Anybody else would like to speak, like I said, directly to this and to the relevance of these documents existing or not existing? Is there like, are you just you, or do you have other people giving you time? Okay, so you have 10 minutes.
My name is Connie Ehrlich, 6830 Ripple Creek Drive, Lafayette, Indiana. I want to address, and Mr. Stahlbaum, you are absolutely correct. The appeal was filed in a very timely manner. It was filed on April 25th, which is well within the UDO requirements. So thank you. And the delay was not caused by us, as you said. I was delayed because of the BZA not being able to get an attorney, and then also the council with withholding funds to Carla when she asked for funding for her attorney. So moving on, I want to address the road use agreement, decommissioning agreement, and the drainage agreement. As we can all agree that those are legal documents. And we can all agree that the exhibits were not completed at the time that they were signed in November 3rd of 22. That's quite obvious. They are not a living document. They cannot be adding acres 3 hours later or 3 years later to the original application and also to this agreement. The UDO states that if there's any major change in application, that it would require re-permitting. And I know Carla and the APC had discussion on this, and they talked in great lengths about swapping ground out would require a new application. I think adding 685 some acres is a major change, which would also require reapplication. Then I also want to say that the decommissioning plan that Carter's referring to, the 3 that were submitted in January 17th of 25, were actually plans. They weren't really signed or approved by the commissioners. The agreement that was signed for decommissioning was October 23rd. That document was signed, but again, the exhibits were incomplete. Now we're talking about adding 685 acres in 2025. So clearly, these acres were not a part of the plan. They were not the intent when the road use agreement was signed, when the drainage agreement was signed, or the decommissioning agreement was signed. And I just want to emphasize that this appeal is not a witch hunt, and it's not an attempt to throw Carla under the bus. Quite the contrary. As you all know, one of the plan administrator's responsibility is to enforce the UDO. In my opinion, certain commissioners and previous county attorney was unjustly interfered with that process and authority given to the plan administrator. So Carla and Mammoth Solar must, in fact, follow the requirements of the UDO. In respect to the permit number 4242, those requirements were not followed. The UDO is very clear that the road use agreement, drainage agreement, and decommissioning agreement must be in place prior to issuing the building permit. Ultimately, the initial decision rests on the plan administrator. Challenges to that decision go to the BZA, not the commissioners. Your job is to hold her to the requirements of the UDO, and the commissioners should not inject themselves into the process, or her job should not be negatively affected. Please vote to enforce the UDO requirements, empower and require the plan administrator to fulfill her job responsibilities. So please revoke permit number 4242. Thank you.
Is there anybody else that would like to speak in regards to this? I think you still have time anyway, because you were using her time.
Describe what they're talking about. Section 2.1 of the road use, similar language in the drainage agreement. I'm sorry to waste time back in at horse. Middle of section 2.1, if a developer desires to include additional roads or portions thereof as designated roads, developer shall submit an updated version of the maps. The county, which to the extent appropriate, revise or supplement the road condition in order to report on the such additional roads. It's meant to be updated over time. That's simple.
Okay, any other individuals like to speak on behalf of themselves over these specific items on here? Give me one sec, because I'm going to give you time. Anybody else? Okay, seeing none, I'm going to go ahead and ask Mr. Kuchme. You have a 5 minutes rebuttal. Anything?
Even if the agreement says, you know, that you can submit an updated version of apps, it doesn't change. Nothing in those agreements erases the requirements of substantial change. You have to submit tab 2 in your binder there. Berger was council. They had indicated this requires a new permit, requires a new permitting process. That was never done. Relying on the documents 3 years prior, incomplete documents 3 years prior. They may not even be complete now, but if they were complete, that was still not done until after the permit was issued. They didn't comply with the.
Any questions from the board before we begin kind of discussing ourselves? No? Okay, so seeing none, I think we should go into this once again. I'm just going to reiterate kind of what we're here for again. This is not about our opinions on solar. I just want to make that very clear because this is a yes or no question in my mind. And the question really comes down to, did a decommissioning plan, financial assurance bonds, and a road use agreement exist prior to this permit being issued? I think that is really the question that we have right here. And I think if we can say that they did exist and they incorporated those pieces, then the answer is yes. If they didn't, then they didn't, and that's an issue. One of the things that I keep hearing over and over again, I just want to make sure this is accurate. I keep hearing that there needed to be a new application submitted if there was going to be a substantial change. It's my understanding there was an application submitted prior to about this new. It's my understanding there was an application submitted specific to permit 4242. Is that accurate? Or if it's not, please correct me.
That is accurate, and you all did get a copy of that in one of the emails I've sent you.
So, because I think that is a piece that I've seen. Going through a lot of the information, well, I've gone through it all, but going through the information that we have been handed in the last few weeks, there was something that, and I think it was alluded to today, and I think it's actually alluded to in 2 of these things. There was a statement made by Jenny Monroe at a commissioners meeting on March 17th, kind of alluding to the fact that there was not a road use agreement. I'd like to ask a question about that. I don't know, is that person here that would like to answer my question? No, she is or is not, or someone on behalf. Can you add some clarification to what was said there? So we read the minutes and basically it summarized that the finalized document wasn't done yet, and I'm paraphrasing, but it did allude to the fact that this did not exist yet.
Understood. So she submitted a comment to the board today, clarifying that. We understand that, you know, I'm speaking on behalf of Jamie Monroe, PS Engineering. I'm Tim Howell. We understand deal references, comments made by the PS Engineering at March 17th Commissioner meeting suggesting construction began without approved RUA. We want to clarify the record. At the time the permit issued, the county and developer were operating under an existing RUA that included a general haul route map. They believed that documentation allowed work to begin. After permits were issued, PS became involved to incorporate additional requirements requested by the highway superintendent. These included changes to the traffic flow and delivery routes. Those modifications were still in process at the time of the March 17th meeting. When asked during that meeting, we stated that an updated map was not yet finalized. Our intent was to explain that revisions were underway, not to imply that no RUA existed or that construction lacked authorization. PS was not part of the permit issuance process, nor did we recommend revocation of the permit or a stop work. Any interpretation suggesting otherwise is
Okay, thank you. Did you guys have any questions for him about that statement? Seeing none. So that, because like I said, that was something that kind of hit me differently because it was a statement at the commissioners meeting, but I also kind of think as we go through this, the existence of a document means more than a statement about whether or not a document exists. And I go back to, do these documents exist? When I look at things, I'm going to be honest, I'm holding the documents that we say don't exist in my hands. So I don't, that I guess is my question is, to me, this is a very cut and dry thing. And if the documents don't exist, I shouldn't have them. And I go back and, so I went through and I've checked to see, you know, what these dates are. And these documents, everything that I have seen, there's a piece dated prior to the issuance of this bond, or the issuance of this permit. I don't know if I'm missing something, or what are your thoughts? Or Carla, do you have anything to add to that? Do you feel, Carla, that do you have the required documents to issue the permit? Do you stand by your decision to do that?
I stand by my decision based on the fact that I received them and I've submitted them to your board.
Any comments from other board members? Nothing?
I was just kind of curious if our attorney has anything to say.
We have a position that somebody would like to make a motion, whether we, right way to say this. Do we have a motion to either adhere to the petition and issue a stop, or to accept the fact that the documents are present? I mean, can I get a motion from somebody on the board to do one way or the other, and then we'll vote accordingly?
I make a motion that the documents did exist and that we.
So there is a motion just stating that the documents did exist and that no action to issue a stop order is needed, required. That is one motion that is out there. Can I get a second to that?
Second.
Yeah, we have a second. All in favor of that motion?
Aye.
So that motion does pass. Ms. Dickey, I want to just reiterate for the record, you did abstain on that, correct?
I did.
Okay. All right. Anything else beyond the board for this specific instance? Seeing none, we will find my agenda. Seeing none, we will go into old business, which we have none. We have no other business. We will move into public comment. Do we have any public comment tonight? Seeing none, we will go into adjournment. Can I get a motion to Go ahead, sir.
I just don't understand why, every time I say, why don't we look at Stark County, because they're just 5 miles north of us, and they've had 4 years of experience with it, that I get eyes are rolling from the group up here. I haven't seen any new restaurants. I haven't seen any additions in Stark County. I haven't seen anything positive come out of that. They were supposed to put in a bike trail. Mammoth was supposed to put a bike trail between Bass Lake and Prairie Trail. They never did that. Doesn't exist. Finally, what they did, the Prairie Trails Club, is they used an existing road, so people have to ride their bikes on the road. So they failed to meet their obligation on that. Also, they're supposed to put a second pump in at Bass Lake. Mammoth Engineering. This is how they got the vote in Stark County. This is how they got over the line to put all the solar panels that you see, was that they promised a second pump, which would keep Bass Lake at a higher level. Guess what? No second pump ever came in. So Mammoth Engineering is not meeting their obligations. And I don't understand why we're not asking people, and these farmers all signed non-disclosure agreements. Wonder why? Yes, of course, they're probably getting the minimum payments in the contract because they're not producing any power. But they're getting minimum payments. So I suggest that somebody here on your board send somebody to Stark County and ask people, because it's Mammoth. Mammoth is in Stark County, same company. Why don't we use that opportunity to find out how to go forward with the solar? Because, things could go downhill real fast. They're LLC, Limited Liability Corporation, for a reason. That's all I had to say. Thank you.
I'm actually going to respond and say, this was the time you could say anything like that you wanted to say. And notice the problem with what you were saying earlier was that we were specifically discussing this appeal. And our job isn't, we have no control over this. I mean, we have control over this appeal, but we don't have control over this project. We're not the ones who granted permission. That's not our role. Our role was specific to deal with this appeal and to decide whether or not these documents existed. So I just want to make sure that you understand, that wasn't against you or anything else. It was trying to keep things on track. This was the correct forum where you had the floor, and that's why you weren't interrupted. So I just wanted to make sure that that was clear. So, anybody else have anything to say? Yes, ma'am. Can you come up here, though?
Stark County.
Okay, anybody else have anything else to say? All right, seeing none, can I go ahead and get a motion to adjourn this meeting at, I'm sorry.
I just want to end on a positive note. I very much so appreciate all of you using your mics so that we could hear you, especially when we're listening to them online. It makes a big difference, and I appreciate it.
So can I get a motion to adjourn at 7:28 p.m., please? I have a motion. Can I get a second? All in favor? Aye. We are adjourned.